Thank you very much for still being around, and I hope you enjoyed the lunch. We still have one more session to go, and looking forward to it. My name is Karina Greif. I'm a Robert Wood Johnson Health and Society Scholar in my second year here, one of the organizers. And I want to thank everybody who's worked so hard in making this happen, and all the speakers who've traveled so long distances to come and speak to us and share their wisdom. Some of them have had to wake up quite early yesterday to get here, so thank you for that. We are having beautiful weather, so I hope you have a little chance to walk around Ann Arbor. And this particular session is going to be about the effects of incarceration on social networks and neighborhoods. We invited 3 distinguished scholars to address issues related to the financial sanctions as a result of conviction, the neighborhoods that ex-prisoners are able to move into after release from prison, and relationships that are affected by incarceration. Our first speaker is Alexis Harris, an associate professor of sociology at the University of Washington. Her research and teaching interests are in social stratification and inequality, and on the juvenile and criminal justice system, race and ethnicity, qualitative research methods. She's a very productive scholar, for sure. I'm not going to name all the journals, but very big journals and very impactful, and is currently working on a book manuscript that investigates the imposition of monetary sanctions to persons convicted of felony offenses in the United States and Washington State. And we'll give the floor in a minute. The second speaker is Mike Masalia. His work focuses on the social consequences of the expansion of the penal system, the relationship between the use of legal controls and demographic change in the United States, and patterns and consequences of criminal behavior over the life course. And current research projects examine historical variations in the U.S. criminal deportations, as well as the relationship between incarceration and neighborhoods attainment. And this is what he's going to focus on today, I hope. And he's now an assistant professor at the University of Wisconsin. Teaches classes in criminology, delinquency, and deviance. And the third speaker is Megan Comfort, a senior research sociologist in the RTI International, and an adjunct assistant professor of medicine at the University of California, San Francisco. Her research focuses on the repercussion effects of incarceration on the health and well-being of people in and recently released from correction facilities, on their families and the social intimates. She's the author of Doing Time Together, a book on love and family in the shadow of prison. It's an ethnographic study of women and relationships with incarcerated men. She has some really interesting findings that I hope she'll get to develop more on, especially on the concentration of incarcerated people within the network of the participants in her study. And I'm not going to give away their talking points, so I'm going to stop now. And thank you very much for coming, and looking forward to further presentations like this. Thank you.
Thank you so much for this invitation to speak here today. I'm never sure if it's worse to go before lunch or after lunch, but I really appreciate all of you being here and listening, and I hope we can engage in a discussion after the presentations. My research for the past several years has focused on something called monetary sanctions, and these are financial penalties that are imposed to people convicted of anything. I focus specifically on people who are convicted of felonies, but it's important to note that these people at every level of conviction, contact with the juvenile, lower municipal courts, criminal courts, receive financial penalties. Oops, yeah. Pull up my presentation would be good. Thank you. My students will go for like 15 minutes and tell me that my PowerPoint's not up. So thank you for letting me know.
No.
Perfect. Okay. So in terms of an outline, excuse me, I'll be speaking about the book manuscript that I'm developing right now around monetary sanctions. And since Mark has already presented the context, I'm just going to jump right into what's happening with monetary sanctions. I'll begin by briefly contrasting my work with what frequently sociologists, criminologists talk about in terms of unintended consequences, and talk about my work trying to frame it as an intentional consequence. And then I'll move in and provide a little bit more detail on what monetary sanctions are, and then use my data to show how these are intentional practices of the contemporary criminal justice system, consistent with past means of social control of poor and marginalized people, and then hopefully provide some time for discussion. So monetary sanctions, social control, and my conclusions and discussion. As a result of our very exceptional criminal justice system, a body of legal scholarship has developed now to look at the consequences, which are often called collateral consequences related to criminal convictions. And this research really focuses on the disintegrative consequences of involvement with the criminal justice system. They range from looking at the impacts of felony conviction on civic participation, employment outcomes, family, housing access, immigration, and also financial impact. And these are all areas that are impacted as a result of felony conviction, but much of them, the consequences are related to the societal stigma that individuals receive. So we focus on housing managers or employers, people in the community who we really don't necessarily have control over their actions, who stigmatize and discriminate against people with felony convictions. Sociological research is focused on the other areas, but obviously has also, many of you in this room have focused on health outcomes, neighborhood, community reentry, and community distrust and fear of the criminal justice system. And so due to this legal status, that this sort of newly status that people can discriminate against because you have a felony conviction, Michelle Alexander, many of you who have read her work, has recently called this the new Jim Crow, right? Where felony convicts can be legally discriminated against and treated as second-class citizens. In contrast to the collateral consequences research, I really frame my work sort of in a couple areas. One, I think it's really important. We talk about mass incarceration. I would rather talk about, similar to what Sean was talking about, the importance of just conviction. So if we think about mass conviction and the consequences of that. So people with felony convictions, not necessarily go to prison, but they go in and out of jail, they are placed on probation, surveillance, have a host of other consequences. And so it's important for the framework to think about this sort of a large set of people being tagged as felony convicts and can be discriminated against. But also, the vast majority of them have something called monetary sanctions that they're required to pay. So this includes fines, fees, costs, surcharges, and interest. So for example, in Washington State, at the day of sentencing, so the day that you're given the number of jail days or the prison days or sentenced to electronic home monitoring, you're also giving the legal financial amount that you're obligated to pay. And in Washington State, you get that payment amount, and that day, interest begins accruing at 12%. If you can't pay it off, every year, the clerks who are the court representatives who collect that amount of money can add an additional poverty penalty of $100 surcharge for the collection costs. Prior to 2 years ago, even that interest began accruing while you were in jail, while you were in prison. Currently, there's legislation that allows for, once defendants are released from prison, if they can show an accounting of all of the interest that they've paid and make an argument that it's a manifest hardship, that they don't have the ability to pay it back, then the courts could waive the interest that accumulated while they were in prison. So this becomes an enormous burden. Since 2003, the Washington County clerks, where my research focuses, the Washington State County clerks are responsible for the collection. And until one pays these off, they cannot defer prosecutions, they cannot carry weapons, serve on juries, seal their records, vacate or dismiss their original convictions. They cannot receive clemency or pardons. They cannot vote. They cannot hold public office. They cannot be a full citizen until they pay off this legal debt. Before I move on talking a little bit more about the monetary sanctions, I do want to note and sort of provide a context for these, that there are a host of other financial consequences to a felony conviction that I'm not addressing. So I'm just talking about a little piece of the financial consequence. But it's important to note that there's also restitution that is charged to defendants if there was a victim in the offense, and it attempts to make the victim whole. And there are also costs related to most of every charge that can be imposed. So if you're sentenced to a drug and alcohol assessment and treatment, you have to go pay for that assessment, and you have to go pay for that treatment in the community. If you don't, then you're in violation of your court orders and can be sent to jail. Domestic violence treatment, electronic home confinement. In King County, it costs $40 to hook it up, and I think the charge is $15 fee per day while you're on electronic home monitoring. If you don't have a working phone in your home, you can't be on electronic home monitoring. That's the Martha Stewart bracelet. DUI classes you pay for, the victims panels you pay for, work release you pay for the jail per jail day, per prison costs. That is discretionary, but it can be imposed, and it's imposed across certain counties in Washington. Probation supervision fee. You pay for everything that you're sentenced to, or at least you're charged for it. A sample of possible legal financial obligations in Washington. There's a lot of discretion in the imposition of monetary sanctions in Washington state. But what is viewed as mandatory across the state is something called a victim penalty assessment, which is $500, and a DNA collection fee of $100. It varies, again, from the courts that I've observed. In some courts, the judges understand that your DNA doesn't change. So if you've had a prior felony and you've paid for that DNA collection fee, you won't be asked to pay it again. However, in other counties, I've seen people who have paid it in the past who have had prior felonies and have to pay the DNA collection fee over and over again. So what's viewed as mandatory is $600 per felony conviction, per case. And then what's viewed as optional are your costs of your public defender if you can't afford one. One's appointed to you, but you do have to pay for it. And that ranges from $400 to $1,200, depending upon the county that you're charged in. Costs for a jury, bench warrants, if they went out, you pay for those. Court costs, the usual court costs I've seen in most of the counties I've studied is $200 per case. So if you have multiple charges, 3 or 4 at a time that you're convicted of, you pay for those 3 or 4 times. What we know so far about legal financial obligations, 2/3 of prison inmates nationally from a BJS survey of inmates have been assessed some form of financial penalty. And what's really interesting is that you can see that there's been a real rise in the costs and fees. So the more recent phenomenon, these types of fees and fines have existed for ever since the creation of our justice system. But what's changing is the amount, type of fees and surcharges that can be charged to the defendant for multiple types of things. Who gets assessed? Based on a sample of data from Washington State, my colleagues and I have found that an average conviction in Washington State, a defendant will receive $1,400 in fines and fees. That's the minimum, or that's the average amount, and then there's a 12% interest on top of that accrues, and then the collection fees. And then you also pay per payment, right? So for a certain amount, the clerks charge you a payment, a fee for processing. In Washington State, we found that Latinos were assessed the highest amounts among other similarly situated defendants. That's about just over $1,600. The factors we found influencing the amount was being Latino, being convicted of a drug offense, and living in a politically conservative counties that had a higher percentage of voters voting Republican. So a summary of the prior research is that monetary sanctions are regularly imposed nationally. Legal debt is typically substantial relative to your expected earnings. If you look at Bruce Western's research and sort of know how much a black or white male will make leaving prison, black males will owe over 200% of what their expected earnings will be. Non-legal factors significantly influence the amount of the LFO sentenced, and monetary sanctions reduce family income and create long-term debt. So as a result of this prior research with colleagues, I decided I really wanted to understand this process a bit more. Our work was pretty descriptive. We understand the amount and we understand the factors that influence it, but how does it work? What purpose do court actors view this as serving? What are the consequences for defendants? And so decided to go back to my ethnographic roots and identify 5 counties in Washington State and just hang out. So in the past 4 years, I've done observations at Superior Courts, sentencing hearings, so looking at the amounts that were assessed to individuals and the discussions around those amounts, if there were any discussions, and then sanctioning hearings. So what happens if someone doesn't pay or is viewed as paying too little amount, insufficient amount. And then I also did interviews with judges and clerks in my courthouses, prosecutors, defense attorneys, and a few with state legislators to try and understand this process in more detail. One of my key arguments that I'm sort of coming away with right now and developing as I'm writing is about the intentionality behind this process. These monetary sanctions are not an unintended consequence, but rather a very intentional legal debt, burden, punishment that is imposed to poor people. And this is important and has implications for several areas that I'm going to highlight. I argue that the intentionality exists at two levels, that monetary sanctions are purposefully imposed to all citizens convicted of a felony in Washington State, regardless of their ability to pay. And secondly, they're used as a form of indeterminate justice in Washington State. As Sean mentioned, when talking about sentencing, we had this movement in the late 70s, early 80s that we really restructured, states nationally restructured their sentencing structure, right? We moved from a very indeterminate, where there's an open-ended number of years or days, months that people were sentenced to a determinate sentencing grid. So in Washington State, we have a sentencing grid that's used to calculate, given a very small range of months for judges to choose from, but based on prior convictions and the seriousness score of the current offense, we have a very determinate number of days or months that people will be sentenced to. Ironically, in 1989, the state legislature in Washington State formalized this notion of legal financial obligations and then created a very indeterminate sentence for essentially poor people in Washington State. So the remainder of the slides, I'm going to describe the intentionality in detail, and then I'm going to say why it's important. So just roll with me for a bit, and then I'm going to explain why I think this argument is a very important one when we talk about the nature of our contemporary criminal justice system. So first, I have sort of 4 pieces of evidence to support the intentionality at the policy setting level. That our legislatures, our policymakers, our justices in terms of case, in determining legal cases, mean to impose this legal debt to people. First, it's assessed to every person convicted of a felony, very basic. There's no distinction between whether or not someone has the ability to pay. They don't have to do that according to state legislature. Now, according to the amount of payment amount that's established, minimum payment amount, they're supposed to assess the ability to pay. But in terms of the overall amount, they don't have to determine whether or not this person has the ability. We also know that interest and collection costs are imposed. So we know the legislators have conversations that, well, what if somebody can't pay this amount of money? Well, we'll impose a surcharge, right? We know that this debt is going to be carried on for a while, and that we can make more money from it. We also know that the debt has been purposefully extended for life. So prior to 2009, cases prior to 2000, the prosecutors had to file for an extension of that debt, and they could only file for a 10-year extension. Currently, the debt's for life. So we changed that legislation. We said we want these people to carry this debt for life. And so that's extended for a person's entire life, and you can't declare bankruptcy on this debt. And the economic sanctions are tied to individuals' civil rights, literally. Currently, we have had a change in the voting rights. So people with debt prior to 2008, they couldn't vote if you had outstanding legal debt in Washington State. Currently, you can have a provisional right to vote. It's a provisional right to vote that prosecutors can request to the court that vote is withdrawn, or the provisional right is withdrawn if you have failed to make a payment or insufficient payment. So you have a provisional right to vote now. Thus, the legislature clearly intended this law to be applied to every person regardless of their ability to pay, and allows the debt to permanently remain with serious consequences even when defendants clearly are unable to pay it off. As a result of this policy, poor people remain under the purview of the criminal justice system for life. So it's purposefully imposed with purposeful criminal justice surveillance and sanctions for non-payment. So this is an example of a quote from legislator Scott, where there's this clear intent about imposing debt. And he says that it's used in the name of accountability. So it's a punishment in attempts to hold offenders even more accountable. And as a consequence, poor people can never fully be redeemed, right, for their offending or for their original offense. They can never be held accountable if they can't pay off the costs. So they're expected to pay for their crimes. They go to jail, they go to prison, they go to community service. In addition, they have a financial barrier imposed to them. In another interview with a legislator, I asked about the reasoning behind linking voting rights to LFO payments, and he describes voting as a privilege, and it was a good tool used to encourage payment. So it gives the defendant an incentive to pay. So it's very clear quickly with conversations with policymakers regarding legislation and also watching the debates that the aim is to impose this legal debt to everyone, regardless of who they are. The second sort of level at which there is clear intention to impose legal debt is the policy implementation level. The assessed amounts are not based on income. I'm just going to move a little bit more quickly here. Outstanding debt requires continual court involvement. So if you have outstanding debt, even if you've completed all other conditions of the court, in many of the counties, you have to continually report to the court. If you change your address, you change employment, you have to report that information to the clerks of the court, and you can at any time be called in, summoned to court to explain your financial circumstances before a judge. So you're constantly tethered to the criminal justice system with this debt. And non-payment can lead to warrants and incarceration. So in several of the counties I've studied, regularly people who do not make any payments at all or who make insufficient payments are summoned to court, warrants are put out for them, they're arrested, they spend nights in jail, and then they're sentenced to jail for up to 60 days for non-payment. Just to illustrate this, there was an example of a grandma that I had discussion with with a defense attorney in what I call James County. A 60-year-old widow who had severe medical conditions. She was ordered to pay $420 in fines and fees and $4,000 in restitution. She had paid off both the way you work. Your payments go towards the original amount, and then you work on the interest. So she had over almost $3,000 in interest. Her total annual income was $8,000. The clerks do a financial declaration, and it was determined that she had $21 in discretionary monthly income. However, she was ordered to pay $50 a month. She was threatened with jail by the judge for non-payment, and the outcome of the hearing was that the judge decided to reduce the interest by 50%. Now, he had the authority to waive it completely, but he reduced it to 50%. What's one thing that is interesting, now in a different county, Alexander County, another one of my counties, the interest is frequently waived. So there are differences, which leads to a big issue about equality and justice within one state. But the main point here is that poor people are forced to pay this, and they're threatened with incarceration. They're also incarcerated. So in James County, they had a policy of auto jail, which has changed somewhat since there was a case challenging this policy. But basically what would happen is that people who weren't paid, warrants were put out, they were arrested, they go to jail. The clerks would walk over to the jail and meet with the defendants while they're incarcerated and say, sign this promissory note saying you're going to pay this minimum monthly payment. And if you don't, you report to jail in 60 days for 60 days. So it's auto jail. That's what they call it. Everyone in the county knows it as auto jail. In Warrant County, they have a pay or stay option that everyone refers to it as pay or stay. Warrants are issued for non-payment, and you're called by the clerks to say, hey, there's a warrant out. If you bring in $300 cash, we can quash the warrant for you. But if you're arrested, and I've seen this any day in this county, you can go sit on their first appearance calendar and look at their arraignment, and they tell you 6 to 8 folks showing up in custody for non-payment. They were picked up at a park because they were homeless and they had a warrant. And so they're told, you can pay $75 now, or you'll stay 15 days in jail. Do you have anybody, how much money do you have in your pocket? Do you have anybody who can come down and make that payment for you? Okay, you're going to have 15 days in jail, literally. So again, a very intended consequence. I've studied Washington through qualitative methods, but this happens in every jurisdiction nationally. I have the statute. I'm working on the chart for it. Whenever I do talks, I like to look up what's happening in that state, and this is just briefly, I have 5 more minutes. Okay. This is briefly Michigan. It's happening here, right? You have your minimum. You're subject to a 20% additional late penalty if you can't pay it. So it's clearly happening here. Okay, so why does this matter? There are humongous implications for inequality. This little joke, but I don't think we need a causal model for this. I think it's very clear if you have this legal debt, it clearly impacts individuals. We have this humongous expansion of punishment. Alongside mass incarceration, we have mass conviction and the mass imposition of legal debt. And it's very intended. We know that we're doing this. In terms of inequality, the system creates a rubber band effect. It cements inequality in our society. We have poor people, undereducated, marginalized people coming into the system. We stamp them with a felony conviction. We load them with legal debt, and they're permanently placed in a state of punishment, indeterminate punishment, with legal debt that they can't get out from under. So legal debt matters because of the large number of people it affects and for the pernicious impacts it has on their life. If you are poor, which most likely you are, if you have contact with the criminal justice system, you can never repay society for your crime. Why does intent matter? It matters because it's a significant inequality-producing mechanism that's not produced by accident. It also provides us with a broader understanding of U.S. society, right? So it can make us take a step back a bit and think about the way our society works. With a broader, when we talk about intentionality with this specific example of monetary sanctions, we can think more broadly about the long history of the country linking poor people and people of color with legal debt, political disenfranchisement, and social and economic marginalization. Labeling people as second-class citizens and treating them as such is not a new process. I'm not claiming that it is. Various formal and informal systems of social control revolved around the imposition of monetary sanctions, and mostly poor and black people who were convicted wrongly and with reason by the criminal justice system. So institutions such as debtors' prisons, convict leasing, and forced labor camps were used by the U.S. state and local governments to extract free labor, but also to remove citizenship rights from individuals. And I argue that the practice of imposing legal debt to people convicted of felonies is a very consistent process. It's just a sort of a modernized version of what we've done in the past. And I guess that's the provocative thing that people say I'm talking about. So within this domain, the impoverished are perpetual subjects of the court system. Defendants who were, for example, which I've observed in stage 5 cancer, arrested for sleeping in parks because they were homeless, or whose only source of income was student financial aid or Social Security, were regularly admonished and punished. These indigent people pled their situations to judges and clerks, but were told to ask their friends and family members for money. Some are literally told to go and hold a cardboard sign on the street corner to raise money. Literally are told. It's a regular process. Take a day laborer job or ask their parents for loans. A lot of this work today is depressing and shocking, but the silver lining, I think, is that this is intentional, right? Which means that we could change it, right? That we know what we're doing, that this is a policy. So it matters for policy engagement. 3 questions I ask: is it effective? Is it efficient? Is it ethical, right? No, it's not. And because we know it's done on purpose, because we know it's done by the state, we can change the policies that lead to this. We can change the loophole with discretion that people have to impose it. So I went over on time, but thank you so much for listening.